You admitted in your Facebook post that you had no
I
defense
admitted
to the
that
eviction
at that
case.
point in time. Sorry to
Ma'am,
interrupt.
this is not a time
And
for you to interrupt.
to make a mockery of the court Godwin is not entitled to just stay in her house rent-free month after month after month.
Hey court nerds, this is a follow-up to the wild case we watched in October. You remember? Our tenant claimed she was too broke to pay rent, but then went off about a retaliation case, bizarre conspiracy theories, and her endless lawsuits against everyone under the
If
sun.
I could afford my rent, I would have been paying the rent, but so I need to appeal. I'm also filing a retaliation case.
This deadbeat who hasn't paid rent for 4 months and who does nothing but file lawsuits all day long against anyone and everyone.
The last judge gave her a break, letting her stay in the house if she paid rent into escrow. Spoiler alert, she didn't. Now we're in front of a no-nonsense judge in a new court, and the landlord's back, demanding action.
All right, good afternoon. CV 24-5566, Yolanda Brommer versus Heather Godwin. Mr. Akhtar has appeared already on behalf of the plaintiff, and Ms. Godwin has appeared already pro se on behalf of herself. That's great. We're ready to proceed. This is a de novo appeal. I see that there was a late filed motion to quash. There's not going to be a quash on a de novo hearing trial, but I'm ready to hear both sides. The order of the proceedings will be plaintiff will give an opening statement, a brief opening statement, just a summary of the facts that they intend to present them. And then the defendant has an opportunity to do an opening statement as well. Once again, very brief, just kind of a summary of what's going on in the case as they see it. And then plaintiff may present their case in chief with any witnesses, testimony, and any exhibits they wish to offer. Presumably they've downloaded those into Box, so we can move this along as far as exhibits go. Defendant will have an opportunity to cross-examine any witnesses, make any legal objections to any documents offered. And then after plaintiff rests, then the defendant has an opportunity to also present any evidence by testimony and any exhibits they have downloaded into Box and offer those. And again, conversely, plaintiff will have an opportunity to cross-examine any witnesses that the defendant calls, and also to make any legal objections to any offers of exhibits. You are bound and limited by your pleadings in this case, so whatever was filed in JP court and any other amendments that were filed in county court, those are the ones that the court will be considering, and no other legal positions because you're bound by the pleadings that you filed. All right, with that being said, and sometimes parties don't even want to do opening statements, they just go into their evidence, they'd rather begin testifying. That's fine. You just have both parties have to agree to let me know that y'all aren't going to do opening statements. And the second thing is to remember that you are now in a court of record. So there is a court reporter, presumably able to keep up with us, and I know Kathy can. I couldn't, and she'll be transcribing everything in the record, which means that it's got to be clean. And so if you have an objection, don't overrun or talk over somebody else. Just if you have an objection, take yourself off mute, state objection, wait for the speaker to stop, and then, as I said before, then briefly state the basis for your objection. So the first thing I need to check is if the parties, y'all want to waive opening statements and just go into your evidence, or do y'all want to give me an opening statement, which will probably include your statements that you're going to be making? Mr. Akhtar?
I'll be giving a brief opening, Your Honor.
Okay, then Ms. Godwin also will have an opportunity to do that as well. All right, Mr. Akhtar, you may proceed.
Okay, Your Honor, before the case in chief, we did file on November 7th a sworn motion for writ of possession because the defendant, Heather Godwin, the tenant in my client's home, did not pay November rent into the registry of the court. I also called and checked with the clerk yesterday, and again, that still seems to be the case.
Okay, all right, thank you. So right now I have before the case in chief, there is a motion for an immediate writ of possession for to comply with the justice of the peace order, and actually also the rules requiring monthly payments to be made in the registry of the court while the case is on appeal. Mr. Akhtar has indicated that the month of November has not been paid. I note that there was 2050 in the registry as of October 18th. So, Ms. Godwin, did you file any other funds into the registry? Let me put you off of mute first. Go ahead and take yourself off mute. And in fact, let me go ahead and swear you all in. Go ahead and start. Let me go ahead and swear you in. Everybody, please raise your right hand. You solemnly swear affirm the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth.
I do.
I do. And then Ms. Brommer, you're on mute, but I'm going to assume if I'm really good lip reader, that was an I do as well. So yes, she's nodding her head yes. All right, Ms. Godwin.
I did not put I do have the rent. However, because the rent payments are made pending appeal, if I did not win this appeal today, I didn't, those funds would be gone and I wouldn't have the funds to find another place to live immediately.
Okay, I
do
understand it.
Okay, so it was a formality decision, just basically,
I
you
understand.
understand. Thank
I
you.
understand. And while I am very sympathetic toward that, I have to follow the rules, and the rules say if the party doesn't make those registry payments, I don't really have any discretion. I have to go ahead and grant. So I'm going to grant the 510-9C motion for an immediate writ of possession to be awarded to the plaintiff, granting them ownership and possession of the granting them. I'm not granting them ownership; they already have ownership, but possession of the property. So let's go to the merits of the case.
As I understand it, Your Honor, it's sorry to
Ma'am,
interrupt.
this is not a time for you to interrupt me.
Thank you.
Okay. All right. So we're now going to go to the main portion of the case. Plaintiff, you may provide your opening statement. Then Ms. Godwin will have an opportunity to give an opening statement as well. Mr. Akhtar?
Thank you, Your Honor. Okay, to make it very simple, my client, Yolanda Brammer, is the owner and landlord of the rental property that's identified as 86 Austin, Texas, 78748. She and Heather Godwin, who herself is a licensed attorney, although she calls herself pro se, entered into a lease in June of 2022, and everything was going along fine for $2,050 a month rent until June of this year, when she simply stopped paying. June, July, and August were unpaid. We went ahead and served a notice to vacate August 22nd. And as you'll see, the notice to vacate, it complied with all the statutory requirements. It was posted, it was mailed, and just for completeness, it was also emailed to her. She, of course, did not vacate. And so during the pendency of the case, she also did not pay September. She did, after the judgment was obtained in JP court, she did pay October rent in order to make the appeal, but she did not pay November, as we've just discussed. So we're going to be seeking possession, and we're going to be seeking 5 months of unpaid rent, which comes out to a total of $10,250, plus my attorney's fees.
All right. Thank you very much. All right, Ms. Godwin, your opening statement.
My opening statement is that I am appealing this eviction because it's not for non-payment of rent eviction. The eviction, Miss Brammer did not evict me because I did not pay the rent. She had granted me extensions and we had a history of extensions, and she evicted me because of retaliation for my taking advantage of rights that are granted to me under the rent contract, and also retaliation for my requesting repairs to the residence. I'm also requesting that as I understand it, I am entitled to, if I get the funds to the court today, then the writ of possession is dismissed. The motion for writ of possession is dismissed if I have the rent today to put into the court registry. However, like I said, that provision is only for the pendency of the appeal, which is wrapping up today. So That's my opening statement.
All right, thank you very much. All right, Mr. Akhtar, you may call your first witness.
I think I can do this simply by calling Ms. Heather Godwin, the defendant.
All right, Ms. Godwin, you've already been sworn. Counsel, you may proceed.
Okay, I'll go ahead and share screen and okay, Ms. Godwin, I'm putting up on screen what we've submitted and marked as Plaintiff's Exhibit 1. First of all, do you see that document in front of you?
I do.
Okay, and do you recognize this as the lease that you signed with my client?
Can you scroll down, please?
Okay.
No, the lease that I have does not have the irregular font in that fashion. I don't know what happened to the formatting to that lease, but that is not the PDF that I signed.
Okay, well, despite the formatting, do you have any reason to believe that the substance of this lease is not the lease you signed?
Based on my experience with you and this grammar, yes, I have reason to believe that that is probably not the document that I signed.
Uh,
Do I agree that I agreed that I signed the lease that said I would pay $2,100 a month? And then I signed, and then we modified the terms of that lease that I would pay $2,050 a month and handle my own utilities. I will agree to that, but I'm not going to authenticate that document right there because it's not what I signed.
okay. All right, in that case, fine. I'll just put that down. I will go ahead and open up what I've marked as Plaintiff's Exhibit 2. This is what we've submitted as our rent ledger. Do you agree that you did not pay rent in June, July, August, or September of 2024? That's a yes or no.
I did pay, yes, I did not pay June through September.
Okay. So at the rate of $2,050 a month, that comes out to $8,200 of unpaid rent, correct?
Correct.
Okay. And as we've just talked about here, you've also not paid rent for the month of November, correct?
Correct.
So that would add up and actually become $10,250 of unpaid rent, correct?
Correct.
Okay. Your Honor, I would move to admit Plaintiff's Exhibit 2.
All right, any objection to Exhibit 2?
No objection.
Thank you. Plaintiff's Exhibit 2 is admitted.
Thank you. I'm going to put up on screen what's been marked as Plaintiff's Exhibit 3. Do you recognize this document, Ms. Godwin?
I do.
This would be the notice to vacate that was served to you on August 22nd, correct?
Yes.
Okay. And it was sent to you by, do you remember receiving it by postal mail?
I did receive it.
Okay.
I have no objection to it.
And it was also posted same date, August 22nd, that being a picture of it being posted to your door in an envelope which said important notice, correct?
It was.
Thank you. Move to admit Plaintiff's 3, Your Honor.
All right, I think I heard her say she didn't have any objection. Plaintiff's Exhibit 3 is admitted.
Okay. The only other exhibit I have for you then is Plaintiff's 4, which I'm putting up on screen. Do you recognize this document, Ms. Godwin?
Yes, I do.
Okay, this would be a post that you put on your own Facebook page, correct?
Yes.
Okay, and in which you actually didn't show up for the JP court and you let us go ahead and get the eviction by default even after you requested a jury trial. And you actually said the words, "I'm letting my landlord and her attorney take the default eviction today. They can sit and traffic. There really is no defense in justice of the peace court for me." Those were your words in your Facebook post, correct?
Yes.
Okay. So you admitted in your Facebook post that you had no defense to this eviction case.
Are you asking to admit it?
I'm not answering your questions. I've asked you a question. You admitted in your Facebook post that you had no
I
defense
admitted
to the
that
eviction
at that
case.
point in time, I did not believe I had a defense to the eviction. I admit that.
Okay. Your Honor, move to admit plaintiffs 4.
I object to the relevancy.
Okay, that's overruled. Plaintiff's Exhibit 4 is admitted.
Okay. In that case, I have no further questions for this witness, Your Honor.
Ma'am, would you like to testify directly, or you want to wait until your case in chief?
I'll, I'll wait till my case in chief.
Okay, thank you, ma'am. All right, Mr. Akhtar, you may call your next witness.
Okay. I will go ahead and call up my client, Yolanda Brammer.
All right, Ms. Brammer, you've already been sworn.
Okay, Ms. Brammer. I'm going to go ahead and put up what's been marked as Plaintiff's Exhibit 1. Do you see that on your screen?
Second, I do, yes.
Would this be a copy of the month-to-month lease that you emailed me that you and Ms. Godwin signed?
Yes.
Okay. Did you make any substantive changes to this, or
No.
and were these just formatting errors in the way you printed them to me?
Correct. I got it from a website, so that's what I had Ms. Godwin sign.
Okay. And we've heard her testify that you all originally signed this lease for $2,100 in rent and later agreed to make that $2,050 in rent, correct?
That is correct.
Okay. Then, Your Honor, I'd like to admit this as Plaintiff's Exhibit 1, the lease.
All right, any objection?
Yes, that's not the lease that was signed. Objection.
All right. Oh, thanks. My video is not on. Yeah, that's a good reminder. Thank you, Brandy. All right. All right. So, Mr. Akhtar, do you have a response to the objection as far as the authenticity of the document, the originality of the document?
Yeah, I mean, my client has testified that it is the lease. It's just a formatting error in the way she printed it off and was able to get it to me.
All right. Keeping in mind the objection of the defendant, I'm going to go ahead and admit Plaintiff's Exhibit 1.
Okay, thank you. And Ms. Brammer, you've had to hire me to try to evict Ms. Godwin, correct?
That's correct.
And what hourly rate are you paying me?
$300 an hour.
Okay. Thanks very much. I have no further questions for this witness, Your Honor.
Thank you, Ms. Godwin. Do you have any questions?
I don't.
All right. Thank you, ma'am. You're excused. Mr. Akhtar, next witness.
Okay. The last witness will be myself to testify to attorney's fees.
All right. You may do so. Thank you.
Thank you. I'm putting up on screen what I've already submitted to the court in box as Plaintiffs 5. I just have to say, by way of really brief preface, that Ms. Godwin has really bombarded not only the JP court, but also the county courts and also the district courts, and is also threatening to file in the federal courts with a number of different filings, which are all tangential to this case. I have done my best to conscientiously highlight only those attorney's fees that have to do strictly with the JP eviction and then this county court appeal. So I am representing my client at the rate of $300 an hour. I was licensed in November 1st of 2000. That's a very reasonable and competitive rate and has been made necessary by the defendants' multiple filings and all kinds of creative attempts to try and stay in this house while paying no rent. It began in August 20th of 2024 when I conferred with my client, and then we drafted the notice to vacate and proceeded with the petition for eviction. And it continued through the months of September, October, and now this month. When it comes down to the end, I've totaled up that up to and not including today, the total of attorney's fees has been $4,230.76. That's strictly limited to the eviction and the appeal of the eviction. That does not include the court costs. As far as today, I will calculate that there's been an additional half hour of attorney time. So again, at my rate of $300 an hour, that's another $150. So if we were to add that, that becomes $4,380.76 in attorney's fees that we're asking the court to award on top of the unpaid rent as well as possession. I seek to admit plaintiff's 5, Your Honor.
Any objection?
No objection.
Thank you, counsel or litigant. I'm not sure what stage you want to be on, but thank you. Plaintiff's Exhibit 5 is admitted.
Okay. With all of that, then, Your Honor, plaintiff rests.
All right. Thank you very much. Plaintiff is rested, and now, Ms. Godwin, you have an opportunity to present your case in chief and present any witnesses that you'd like to offer.
Okay. I will. This case concerns
Are you going to hold on? Are you testifying? Are you going to call yourself to testify?
I'm calling myself to testify.
All right. Thank you, ma'am. All right. You may testify in narrative form since you're representing yourself, beginning, I guess, with your name, and then you can proceed from there. Thank you.
My name is Heather Godwin. I am a tenant here. I have been a victim of trafficking for a very long time. And Yolanda Brammer reached out to me when I was in my previous apartment and complaining about trafficking. And she offered to put me in this house. I was an attorney for her brother when I was working for Eric Willie, and I was having severe hacking issues when I split from Mr. Willie's firm. And I could not handle her brother's case well. And she called me and she said that she was unsatisfied with the amount of time I was taking, and that she was going to, and that her brother wanted to move the case along. And I said, I had no problem with that. I totally understood. And she said she would call me back. And she called me back about a half an hour later, and she said, everybody knows what's happening to you. And I was amazed, and because I kind of felt like I knew that people knew that what was happening to me. And she reached out to me and she said, do you need a place to stay? Are you in fear for your life? And I said, yes. And she said she had this place available and that her daughter had just moved out. And she was going to rent it out for an Airbnb, but I could stay here as long as I needed to. And so I came here and I moved in. But and I thought that I was free from everything, but I was still hacked and my cases were still being messed up with, and I was complaining about that online. And I came back from being out one day and the batteries were out of my thermostat. So I was wondering how they got in. And that's when I realized that she had rented me a place that had no patio door lock. The patio door lock had been hollowed out like that. And so I called her up and I said, and so I'd like to offer Exhibit D6 into the record.
All right. Any objection to D6?
Objection to relevance, Your Honor. These are repair and remedy claims that have already been dismissed in JP court due to non-payment of rent.
All right, I'll go ahead and allow it. Defendant's Exhibit 6 is admitted.
And so I sent it to her and she said, oh, don't worry about that. My son-in-law did that. And I said, well, it's broken. And I said, I wanted to replace it. And she said, no, do not replace it. And I said, I can just replace the handle. I don't have to replace the door. And she told me no. So I put up a sucker, like one of those, like a sucker type hook onto the glass so the glass could not be opened. And I replaced the batteries in the thermostat, and I filled all the holes in the walls. But I was still being bullied online, and then and still complaining online about it, because I realized that I was still in the same stuff. But at that time, I really believed Yolanda was an innocent bystander. Like, she, through some weird circumstances of events, she was being manipulated and used because she was my friend. And right now I am actually reading from defendant's first amended answer, plea and abatement and motion to dismiss cause of action that was filed in this matter on October 4th.
And those were all handled by the JP court, correct?
Yes, Your Honor.
Okay.
This
All
answer.
right. So I just want to go through.
Understood.
Yeah. All right.
So
okay.
I'm just
anything else?
Yes, and then on September 3rd, 2023, I was very upset, and I told Yolanda that I wanted to put a fixed lock on the patio door so nobody could come in. But then I was just so hounded, and just they're never going to let me go. That's what I thought. And so I sent her a message, and I said, they're going to keep on filming me, and they're going to keep on making money off of my nudity for as long as they can, until I can flee to where I can protect myself and they have no power. And she answered yes. Like, she admitted that it's happening. And for the life of me, I don't understand why I'm having to file all these things. I don't know. I don't understand how it is that all this litigation can be created around when there's this absolutely salient fact just right there in black and white. But I am still having to prove over gaslighting that this is occurring. So I stayed living here. I had a number of family law cases. I had a very large family law case that I thought was coming. I was also suing who I thought were the main perpetrators in the trafficking issue. And Facebook is actually a part of that. So it was removed to federal court. That was dismissed. Except for Facebook. Judge Pittman told me to sue Facebook in Washington, which I will. Or if I go and file suit if I leave here and go to New Orleans, I can file suit in another district court. I was sanctioned from filing again in Texas District Court. That's what I was sanctioned from doing. Not the circumstances and suing on the events and the trafficking. And I was not served with any slap lawsuits in retaliation for that suit as well, which should show you at least there's that level of civilization going on. And I'm also appealing the trafficking suit against Miss Brammer, because in that motion to dismiss hearing, the judge kept on saying appeal, 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 which opened up my mind to the realization that on the trial court level, much graft and much extortion and pressure occurs. However, when it comes to going to appellate court and the concept of having this fact pattern in black and white in the books for other attorneys and the whole world to see forever as an appellate court in the reporter, that's not going to happen. an appellate court is not going to look at this fact situation and say, oh yeah, that's okay.
All
So,
right, ma'am, we're gonna have to wrap this up. So is there anything else relevant
yes,
to
I would like to
the,
also.
hold on, stop talking for just a minute. I need to have any other evidence that you wish to present as to the lease and the payment under the lease.
I would like to say also that in January, I requested an extension on the lease for Miss Brammer. And she said, of course, you can have an extension. So I took advantage of that extension. And when I was able to pay her, I said, thank you so much for the extension. And she said, oh, you're welcome. And I said, I was afraid you were going to kick me out. And she said, oh, I'm never kicking you out.
Really?
And so what happened? So what happened in June was that I was not at the time that I made this. Well, what happened in June was the house significantly started shifting, and I started to have to take care and caulk and fill in holes. And then in late July, in July 25th is when I started covering myself. I covered myself in the bathroom, except when I was behind the shower curtain, and I covered myself in my bedroom unless I was in my closet. And it was at that point that Miss Brammer said, hey, are you all right? She ignored all my texts. She ignored all my texts about, can I get the extension? Will you please respond to me? Please respond to me. All the texts from June 14th about me talking about these are all my texts to her, and she does not respond, which is a facet of emotional manipulation, is withholding information and stonewalling somebody. On July 25th, I began to cover myself in the house. That's when she clued in. Call me. I called her. I tried to text her. I could not get through to her. I was still trying to contact her and talk to her. I hope you're doing all right. Still, I'm covering up. Hey, are you okay? I'm still covering up. I don't want to see you, Yolanda. I'm still covering up. And at that point, I thought it was the music industry, but I don't really know. I don't know. I just know it's happening. And then here she is on August 1st. I'm still covering up. They're still saying, are you okay? Are you okay? Because that's what's a hallmark of the abuse that's been happening to me, is that my protesting is something's wrong with me. Something's wrong with me because I'm not allowing them to film me. It's really insidious. And I think I'm one of the few people, I don't. So this is me explaining to her how I'm going to move. Can you please just, I'm going to move and sue people. And I'm here recounting our conversation with her. I'm recounting, Yolanda, this is what happened between us. And she's not responding. And I'm telling her Zach may have broken the handle, but you forbid me to place it. That's how they got in, and that's negligence. I'm still giving her the benefit of the doubt that she's not involved. I'm still like, please understand what your place is in this. I'm going to have to sue you. She called me up. We got on the phone and she said, "Are you okay?" And I said, "Yolanda, I'd be okay if you just give me the extension on the rent. Just let me know." And she said, "Well, I'm not calling about the rent. I'm not calling about that. Are you okay?" And hers telling me that was telling me she doesn't care about the rent. She is calling me to see if I'm okay because I'm not exposing myself in here, because I'm closing myself off and covering myself off. And I said, you don't, and I said,
All right, ma'am. We need to kind of wrap this up.
okay,
I've got
all right,
the,
well, I'm wrapped up. If you don't get it by now, then I guess you're not going to get it. In response to that, in response to at that phone call, she said she'd have to think about it, and I still covered myself up. And the next day, she said, "You're evicted for non-payment of rent."
okay.
Your honors, can I
Hold
say
on,
something?
Yolanda,
Oh,
Yolanda,
Nope,
no.
you cannot. You
okay.
cannot.
Okay.
All right. Mr. Akhtar, do you have any questions?
No questions for this witness.
All right. All right. Thank you. All right. Ms. Godwin, you're excused as far as the witness goes. Are there any other witnesses you intend to call, or is that it? All right. I'm going to assume then we're going to move forward. Both parties have, I presume, rested, and we can do any closing statements, brief closings, if you wish to do those. Mr. Akhtar?
Yes, Your Honor. Quite simply, I feel badly for Ms. Godwin. She's clearly not well, but that's not my client's problem. Ms. Godwin is not entitled to just stay in her house rent-free month after month after month and just make a mockery of the court system by just suing case after case after case against everybody. She's admitted that she has not paid for 5 months of rent. That's $10,250 of unpaid rent my client has suffered. She's also had to pay me $4,380.76 in attorney's fees. That's through the end of today for doing our best to just get Miss Godwin out. She's filing every possible manner of thing to stay in, but none of it has to do with any defense for her eviction because of non-payment of rent. We're just asking for some finality to this. I know she's going to continue filing things, but she needs to be out of there.
All right. Thank you very much. Closing statement, Ms. Godwin?
Yes, Your Honor. This is not a eviction for non-payment of rent. This is an eviction in retaliation. There's a case that's in evidence. It's Terrace Pines versus Laird, in which a tenant who was delinquent in rent complained about repairs needed to an apartment, and the appellate court found that it was indeed a retaliation of rent, even a retaliation eviction, even though the tenant was delinquent in rent. You can have a retaliation claim, and I have the elements of a retaliation in my answer.
Thank you. All right. Well, I appreciate the courtesy y'all have extended, although I understand from my staff that there have been numerous interactions with both parties, even a party that's represented by counsel. I'll just encourage y'all to continue to be pleasant as you deal with other court staff as you move forward on this matter. I'm going to rule in favor of the plaintiff. I'm awarding her possession of the property. I'm awarding back due rent, and plaintiff has requested $10,250, and I guess that doesn't include the $2,050 that's right now in the registry for the month of October. So in actuality, I'm award damages of $10,300 to account for that October rent, and then order that the clerk's office tender the amounts that in the registry to the plaintiff as an offset for the damages. So then you get your $10,250. I'm going to award attorney's fees of $4,380.76 and court costs to the plaintiff. Because I'm already awarding an immediate writ of possession, I don't know if y'all want me to issue a supersedious bond in the judgment. I can do that if that's requested. Anyone want that? No? All right. Very good. All right. And with that being said, if you'll send us if you might already have sent us a proposed judgment, both on the main case and also on the immediate writ of possession, I'll sign those, and then y'all can proceed as you may, whatever you decide to do. But I appreciate the courtesies y'all have extended to me and my court staff. All right, and with that, y'all are excused, and I can move on to the next case. Thank you so much.
Thank you. Just one quick moment. So I uploaded the two different orders to the proposed orders of box. One was on the writ of possession, which also requested release of the $2,050 of October rent. The other one was not including that amount, and it was for the 5 months that we just discussed.
Okay. All right. Well, my staff will look at it. Thank you.
All right.
All right. Y'all be safe out there. Thank you. Y'all are excused. Thank you. Kathy, you doing all right, or you need a break?
I'm fine, Judge.
You sure?
Yes.
Lena, you all right? Brandy?
Do you need a break, Judge?
Nah, I just want to get this stuff done. That's all.
We're good.
All right.